I am concerned in this next election, presidential election, that the potential exists. I said potential. I don't know what's going to happen, but the potential exists that one of the candidates, or we may have an election, let me put it this way, where one of the candidates wins the electoral college vote and the other candidate wins the popular vote. I haven't even discussed this with you, have I, Mr. Producer? It worries me a lot because I can hear the loud attacks now about it being an illegitimate election. Should Obama win the popular vote and lose the electoral college vote? I'm not saying that's going to happen, but it's conceivable, if not unlikely. But gee, it only happened 12 years ago. I worry about it. I worry about it because it's not only constitutionally legitimate, it's legitimate, period. But that said, I don't think that'll go down very well. We have a gentleman who was on the Chris Matthews show. Let's get that clip ready, where he's kind of right about what he says when Matthews is trying to compare. Well, he's right. When Matthews is trying to compare Bush versus Gore to the Obamacare case, he says, no. Bush versus Gore was corrupt. The Supreme Court was corrupt. Obamacare is a legitimate case. Can you play that, Mr. Producer? Go.
Kelly, is it your view, the same view that would be viewed as a partisan ruling if they ruled against it?
It's hard to see how the media rhetoric would be played out any other way. Certainly, I think the Obama administration would try to play it that way and claim that it was a political rather than a legally based decision.
And that's a problem for the court because you did have Bush v. Gore.
This is
healthcare reform is a political issue.
I wonder if they're thinking like this, John. They better not look partisan.
It's not comparable to Bush v. Gore. It's just not. A stolen election, which is what still many people think about that, is not the same as striking down this. There is a legitimate, very conservative constitutional argument in play here. On Bush v. Gore, it was pure politics and purely corrupt.
All right. Guy gets it half right. That this is a serious case, Obamacare. But he gets Bush versus Gore absolutely wrong. Now, I want to tell you something. My longtime listeners are aware of this from Men in Black, but I want to repeat it now. Was it necessary or appropriate, I asked, for the Supreme Court to enter that controversy? I want to talk about this briefly because of the effort that will certainly be underway to delegitimize the court's decision if it's not helpful to Obama and Obamacare. And I said then, and I'll repeat now, I believe that the U.S. Supreme Court intervened in the 2000 election not to choose a winner, but to rein in the Florida Supreme Court, which was intent on allowing county election boards to recount returns under increasingly flawed standards until the desired result had been achieved, a victory for Gore. Remember, it was Gore who went to court first, ladies and gentlemen, not Bush. Gore. But I also say it was unnecessary for the Supreme Court to become involved at all. The issue would have been resolved under the explicit language of the Constitution by the Florida legislature and ultimately by Congress. You see, I asked, is there any scenario under which Gore could have won? And I said both practically and constitutionally no. There are three basic reasons for this. First, on November 26, 2000, after Florida's returns had been certified by Katherine Harris, Governor Jeb Bush sent a certificate of ascertainment, that's what it's called, to the Archivist of the United States, certifying the election of the Republican slate of electors to the Electoral College as required by federal statute. Once Governor Jeb Bush had done so, no authority, state or federal, legislative or judicial, could force him to withdraw his certification. Certainly his certification could have been challenged in Congress when the Electoral College votes were counted, but federal law recognizes no other authority who could actually certify Florida's electors or the voters of those electors. So once Jeb Bush sent it to the Archivist of the United States, certified to its authenticity, that was it. Second, Once the Electoral College votes were counted in Congress, a challenge of the Florida votes could have required a majority vote in each house to reject Florida's electoral vote, an unlikely scenario, as the Republicans controlled the House of Representatives. Even if this hurdle had been jumped, the House would then have chosen the president by a vote of the majority of the state delegations. Since Republicans outnumbered Democrats in a majority of the state delegations in the House, the Republicans controlled a majority of those delegations. And I have no doubt they would have voted to uphold the election of George W. Bush. Third, since Article 2, Section 1, Clause 2 of the Constitution gave the Florida legislature ultimate authority over the state's selection of electors, it was clear at the time that the Republican-controlled legislature was actually preparing to do just that, had the U.S. Supreme Court not intervened to stop the Florida court's rewriting of state election law. In my view, Gore's litigation efforts were never going to grant him the presidency. The Florida Supreme Court's lawlessness on Gore's behalf was for naught, and the U.S. Supreme Court's decision to rein in the Florida Supreme Court had no effect on the ultimate outcome of the election. This is why it's important, ladies and gentlemen, to understand the Constitution. In the end, there were more Republicans in the House, more Republican majority delegations in the House. So if there was a challenge or the Electoral College vote, once there was a joint session of Congress to count, the process ultimately, if pushed, would have resulted in a majority of the state delegations in the House, which were Republican, voting to make George Bush president. Once the governor of Florida certified the electoral votes to the archivist, there was no litigation of any kind that could reverse it. Game, match, over.